Thank you, Mr. Chairman. Like many of you, I'm concerned about an increasing trend in our nomination hearings. It seems that any and every time we ask a nominee about a questionable statement in the nominee's past, usually one which would make him or her at best undesirable or at worst unqualified to sit as an Article III judge, the nominee will end up trying to obfuscate their extreme views by hiding behind ceaseless remonstrates of I was speaking as an advocate. I was being an advocate here. In fulfilling my constitutional duty to provide advice and consent, I've consistently tried to distinguish between arguments made by attorneys advocating for a client and an attorney's own activist views on the law. Attorney advocates have a solemn duty to represent their various clients and do so in a way that allows them to present arguments that in many instances they may disagree with, that they wouldn't make on their own behalf, but they need to make on behalf of clients in order to give them the best possible defense, the best possible representation. However, when they step out of the role of the attorney advocate and into the role of an activist, we should expect them to answer for any outlandish claims. For example, when they start speaking on their own behalf or start advocating for policy, for their own policy positions or something like that, as opposed to submitting briefs in a court. Increasingly, the nominees before us attempt to hide behind the shield of advocacy, sometimes advocating for a client when they are, in fact, fully engaged in activism in the form of op-eds, speeches, and press interviews that go far outside the attorney-client role. Assuming the role of advocate does not exempt you from speaking with honesty and integrity, we should be wary of confirming those activists who happily sacrifice honesty and facts for overheated rhetoric as federal judges. There is a place, of course, for activists, for people who want to champion this or that political cause of theirs and others who agree with them. It's not always on the federal bench. Making rhetorical points that find their basis outside the facts is a poor trait in an advocate, and it's certainly a troubling trait for one aspiring to sit as an arbiter of facts and of law. Nancy Abudu, the Director of Strategic Litigation at the Southern Poverty Law Center, has, of course, been nominated to be a judge on the U.S. Court of Appeals for the 11th Circuit. This is an important lifetime position, and a position that will, if she's confirmed, put her involved in what is likely in 99% plus of cases that come before the court, that come before her. She'll effectively be part of the court of last resort, the highest court ever to receive these nominations. But again, Director of Strategic Litigation at the Southern Poverty Law Center. This is the same Southern Poverty Law Center scarred by allegations of maintaining a culture of racism and sexism while claiming to defend the marginalized and the oppressed. The same organization that designates individuals, including some of our colleagues on this committee, and groups, other groups and individuals with which it disagrees as hate groups. When multiple senators asked Ms. Abudu whether she agrees with SPLC's hate map and hate watch, she acted as if she were totally unfamiliar with the trademark activity of her organization. Ms. Abudu attempted to evade other questions involving her liberal activism, claiming that she was acting as a legal advocate, even though no clients seemed to be involved. In June 2020, Ms. Abudu wrote a piece for the Southern Poverty Law Center where she claimed, quote, "Our current criminal justice system is one of the most inhumane examples of how racial discrimination operates and can ruin people's lives forever." She then went on to say, quote, "When you add laws that prohibit people with a criminal conviction from voting, it's practically the same system as during slavery. Black people who have lost their freedom and cannot vote. Now, I asked Ms. Abudu in her hearing whether it was appropriate for someone nominated to be a lifetime judge on the U.S. Court of Appeals for the 11th Circuit to say this about our federal court system, the same system of which she will be an active and important part, playing a very prominent role. And she attempted to evade the question by saying that this was a letter that was written, quote, in her role as an advocate. However, as I reminded Ms. Abudu, this is not a legal brief or a complaint. This is not an oral argument in court or a presentation to a jury. There was no client's name attached, and she attached her name to the opinion piece. As Director of Strategic Litigation at the Southern Poverty Law Center, Ms. Abudu said that she has, quote, significant managerial responsibilities, including overseeing all of the organization's legal and programmatic work, in addition to voting rights, which includes immigrants' rights, criminal justice reform, children's rights, LGBTQ rights, and special litigation related to hate groups, close quote. This is significant because in 2022, the SPLC's litigation team participated in cases challenging Alabama's vulnerable child protection and compassion law. The plaintiffs also they filed two different cases in two different federal districts within Alabama and attempted to consolidate them thereafter under a single judge in one of these federal district courts. After being assigned a different judge, the parties then eventually moved to voluntarily dismiss the cases and refiled yet another almost identical complaint or almost identical series of complaints the very next day. In a rare move, Judge Burke opined that the actions taken by counsel could, quote, could give the appearance of judge shopping, a particularly pernicious form of forum shopping, a practice that has the propensity to create the appearance of impropriety in the judicial system, close quote. In response, the Chief Judge established a three-judge panel to conduct an inquiry into whether judge shopping had occurred in these cases. Based on the docket, this inquiry is still ongoing, and Ms. Abudu's employer is still involved in the litigation. Now, what does this have to do with Ms. Abudu? Well, I asked her about this case, given her prominent role being the Director of Strategic Litigation within the Southern Poverty Law Center, and specifically about the unusual allegations and troubling allegations of judge shopping that were made by Judge Burke. She claimed ignorance of the allegations. She stated, quote, as Director of Strategic Litigation, my responsibility is to oversee and provide general management for our cases, but it is the subject matter experts in the litigation team that handled the day-to-day, close quote. When I asked Ms. Abudu whether if she were confirmed she'd recuse herself from dealing with this case, she attempted to hedge, saying, quote, my commitment is I will recuse myself from any case where I'm on the papers, where I played a role in bringing the litigation, and beyond that, I will adhere to the rules of judicial conduct, close quote. That's it. That's as far as she was willing to go. Before voting on Ms. Abudu's nomination, this committee should demand more forthcoming answers from Ms. Abudu with regard to her participation in the Alabama Vulnerable Child Protection and Compassion Act case and statements made by her in her role as an activist. Contrary to the claims made by Ms. Abudu, the role of advocate should not offer some magical, as if talismanic protection from scrutiny. The words, the analysis, and the rhetoric of Ms. Abudu and other judicial nominees should be fully scrutinized by this committee and by the Senate to determine whether each individual nominee is capable of serving as a neutral arbiter. I have grave doubts about my ability to answer that question the way that I would need it answered in order to feel comfortable supporting her nomination. We don't have that information. We should get it before we vote. Assuming that doesn't happen, I can't do that. I can't support her nomination, and I oppose it. Thank you.
So the question is on the nomination of Nancy Abudu to the U.S. Circuit
Mr.
Judge.
Chairman,